Greetings! Welcome to episode 2 of the Politics and Prosecution video series. In this episode, we're going to look at how governments in the United States are structured. As we talked about in the first episode, we have local, state, and federal governments. How do they work? What are their differences? What are their similarities? What are their powers? What are they allowed to do? What are they not allowed to do? This episode is going to examine that as we take a dive into the United States Constitution, looking at its different provisions and how they're relevant to criminal prosecutors. And you may be asking, why in the world are we looking at the Constitution? Why are we looking at all these different aspects of the government when we're talking about prosecutors? Well, at the end of the day, prosecutors work for the government. They are government employees. And so we need to understand how the government works in order to understand where prosecutors fit in that overall picture. To do that, we're going to look at three key things. The first is going to be this notion of federalism. That's basically saying that we divide sovereignty into two different groups: the federal government, or the United States government, and then all the 50 states. In addition to that, we are going to look at what we call the separation of powers. Within each level of government, we separate our powers out into three different branches: the legislative branch, the executive branch, and the judicial branch. This will look at what those respective powers are. And finally, we're going to look at the phenomenon known as the administrative state, the essentially professionals who run the government on a day-to-day basis, and how they interact with the legislative, executive, and judicial branches. So let's begin with this idea of federalism. In most countries, when we talk about the sovereign power of the government, or the power of the government, all of that power rests in the hands of either one person or perhaps a small group of people. So let's take, for example, North Korea. Kim Jong-un is the leader of that country. He holds all of the government power. The government doesn't do anything. The government doesn't have any authority to do anything unless he says that it can occur. Other countries, they run on a system where it may be held in a group of people. If you look at the United Kingdom, in theory, the Queen is the sovereign. She holds all of the power, but on a day-to-day basis, on a practical level, Parliament controls the power. The Prime Minister, who is the leader of Parliament, is part of Parliament. Parliament holds the power. The members of Parliament hold the power in the United Kingdom. So that brings us to the United States, where we have our sovereign power divided. We have created a federal system where we have some sovereignty resting with a national government, the United States government. We have some power residing with the 50 different state governments. Now, what is this sovereign power that we're talking about? Sovereign power simply means the power to exercise government authority. It includes things such as making laws. It includes defending territory. Right? It is the idea that you control this particular geographical space. This is your country's territory. You are recognized as a sovereign power. And as I said, in the United States, we divide the authority to exercise this sovereign power between the states and the federal government. And notice that I said we delegate the exercise of this power, or give the authority to exercise the power, because in the United States we recognize that the people are sovereign. So that takes us right to the beginning of the Constitution. When we look at the preamble to the Constitution, the first three words are "we the people." Right? So it is the people who are getting together and who are creating or giving this sovereign power to somebody else. And in this particular instance, We are going to give those power to people that we elect. And again, that can be on the state level, it can be on the federal level. And so those are going to be our two key sovereigns. The federal Constitution then delineates which power goes with the federal government and which power goes to the state governments. And that is essentially our question of federalism. Is this particular power that we're going to exercise, is it a federal power or is it a state power? And oftentimes you're going to have conflict between the two. Sometimes the states say, no, this is our job. Other times the federal government's going to say, no, it's our job. Sometimes they're going to overlap. But there are also times when it's recognized that it is purely a federal power or purely a state power. When we put this in the context of criminal prosecution, it is a shared power. The federal government can prosecute some things, the state government can prosecute other things, and some things they both can prosecute. And so federalism can become a key piece of any decision on whether or not to use prosecutorial power. Within each of those systems of government, so you have this federal system of government, you have the state systems of government, we're going to further divide up the power. We're going to divide up the sovereign power that's given to the federal government, we're going to divide up the sovereign power that's given to the state government, and we're going to do that in three different parts. We're going to divide the sovereign power into three. The Constitution does this through the first three articles. The first article creates the legislative branch. The second article creates the executive branch. The third article creates the judicial branch. So what we're going to do is we're going to look at each branch in turn and see what powers the Constitution gives them. And we're going to focus on the U.S. Constitution because with a few variations, just about every state constitution now follows the pattern of the federal government, where they divide the sovereign powers up into three different categories. For uniformity's sake, since we can't go into every single state constitution, we'll also focus on the U.S. Constitution because that applies to all of us who are looking at prosecution in the United States. So first off, the legislative powers in Article 1. Article 1, Section 1, essentially gives the power to Congress. It creates this organization called Congress, and then they're going to further divide up the legislative power between two different houses of Congress. On one hand, we're going to have the House of Representatives. On the other hand, we're going to have the Senate. The House of Representatives is going to have 435 members spread out among the 50 states. They are selected or they are determined by population. So now we're undergoing the 2020 United States Census. Once that is all completed, we're going to reapportion the seats in the House of Representatives based on population. So a state such as Pennsylvania, if it loses population, is going to lose representation in the House. They may lose a House member. Whereas a state such as Florida, if they have gained population, they may gain a House member. The sum total is still going to be 435, but the numbers may be reapportioned between the different states. Contrast that with the Senate. The Senate is made up of 100 people. It is 2 people from each state. It doesn't matter how big the state is or what the population of the state is. So Rhode Island, New Jersey, Delaware, smaller states, they have 2 senators. However, larger states such as California, Texas, New York, they have 2 senators. Every state is represented equally in the United States Senate. And that was the original idea behind the House and the Senate, that the House would represent the people, the Senate would be representative of the states. Now, the Constitution gives Congress the power to do certain things. They cannot act outside of the powers that they have been given. These powers show up in Article 1, Section 8 of the Constitution. They basically include the following things. They can lay and collect taxes to pay debts or to provide for the common defense and general welfare. They can borrow money. They can regulate commerce between the states and with foreign nations. They're able to establish uniform naturalization and bankruptcy rules. They're able to coin money and regulate its value. They are able to provide punishment for counterfeiting currency and the securities of the United States. They are able to establish post offices and post roads. They're able to grant patents and copyrights. They are able to create inferior courts. We'll see in Article 3, when we talk about the judicial branch, that it only created a Supreme Court. It left it to Congress to create the inferior courts. They can define and punish piracies, felonies on the high seas, and offenses against the law of nations. They're able to declare war. They're able to raise and support armies. They're able to maintain a navy, regulate the land and naval forces. They're able to provide for calling forth the militia to execute the laws of the Union, suppress insurrection, repel invasions. They're able to provide for organizing the militia when called into service. They're able to exercise exclusive jurisdiction of the capital area, and that would be the District of Columbia. And they're able to make all laws necessary and proper for doing any of those things that I just went through. Now, there's going to be certain things that, from the prosecution standpoint, are most important. Right? The idea to pass laws that criminalize counterfeiting United States currency, to be able to establish laws regulating piracy, the laws against nations, things of that nature. Obviously, the courts are an important part of that. And so all of these things have an effect on what Congress can do when it comes to creating criminal laws that prosecutors would then go out and enforce. While Congress can do these things, there are certain things that Congress can't do. The Constitution prohibits Congress from doing these things. Number one is to suspend what's called the Writ of Habeas Corpus, except in times of rebellion or invasion. The Writ of Habeas Corpus is something that prisoners could file if they believe they are being held in violation of their rights. It literally means to produce the body. It requires that whoever is holding a person in custody must produce that person in court and justify why that person is being held. Congress cannot pass bills of attainder or ex post facto laws. The key there is the ex post facto laws, where you cannot make something criminal and then prosecute people for violating that law before that law had taken effect. So let's say tomorrow we say that it is illegal to drink coffee. And so everyone who has had coffee today, you cannot be prosecuted for violating the law, because that would be an ex post facto application of the law. They are not able to levy a direct tax unless it's in proportion to the census. They cannot also impose a tax on articles that are exported from a state. So if I made a product in North Carolina and I sent it to Virginia, the federal government cannot tax me for taking it from North Carolina to Virginia. There is no preference to be given in a commerce regulation to one state over another. I can't say that all goods produced in North Carolina must be exported via airplane and goods produced in every other state must be transported by train. Right? Two different regulations for different states. We can't do that. They cannot borrow money from the Treasury unless it is apportioned by law. And finally, they cannot grant any title of nobility or allow any person who is holding office in the United States to receive any present, emolument, office, or title from any foreign state. unless, of course, they consent to it. And so there is also that provision. So those are the different things that Congress cannot do. And so if Congress were to create a law that violates one of those provisions, it would not be constitutional. Now we're going to move on to the executive branch and what the executive branch can and cannot do. Article 2, Section 1 says the executive power shall be vested in a President of the United States. And in today's world, there is a great deal of debate about what that term executive power actually means. And there are people on both sides of the issue. Some will say that it is a very extensive grant of power, that the president has pretty much the power to do anything the president wants to do. Others are saying that the power is much more limited, that executive power was meant to only cover a very small category of activity. The Constitution doesn't spell it out very much. They don't say what the president can and cannot do in the terms of this executive power, with a few exceptions. So, number one, they impose some requirements on who the president is. Right? The president must be a natural-born citizen and is not somebody who immigrated to the United States. They also have said that the president must take an oath of office before assuming that particular role. And that oath is as follows. I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. And so that is constitutionally required, that they will take that oath. Now, what powers have been enumerated or given to the president specifically? Number one, the president is commander-in-chief of the armed forces. Number two, the president may ask for opinions from the head of executive departments upon any subject related to their duties. So the president can turn to the Secretary of State and say, I need your opinion on how we should deal with North Korea. I need your opinion on how we should conduct diplomacy in this particular conflict. That's what they mean by asking for opinions. The president also has the power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. So if anybody is convicted of a United States crime, a crime against the United States, the president has the power to pardon that person or to suspend or essentially cancel their sentence. The key limit to this is it's only for federal crimes. Here comes that notion of federalism again. Federal crime, the president can pardon. If it's a state crime, if it is a murder, just an ordinary murder in a particular state, the president has no authority to pardon that person. That authority would rest with the state's governor. The president is able to make treaties with the Senate's consent. And so the Senate must advise and consent on that treaty. The president also has the ability to nominate with the Senate's advice and consent, and then appoint ambassadors, other public ministers, judges of the United States Supreme Court, and all other officers of the United States. Now, there are some exceptions to this. Congress may allow the president, judges of the Supreme Court, or department heads to appoint inferior officers of the United States. And so now we've drawn this distinction between sort of the key or high-ranking officials of the United States and inferior officers of the United States. Also, the president may appoint, when the Senate is in recess, people to these different positions, but their terms would expire once the next congressional session concludes. So these are what we call the recess appointments. So if the Senate adjourns for a period of time and that they cannot advise and consent, the president may appoint somebody to a particular position. Now, what has happened in recent years is the Senate never adjourns. They are in session every day throughout the 2-year term of that particular Congress, and they've basically taken away the president's recess appointment power. Next, the president has to give Congress information about the State of the Union from time to time. This is what we know as the State of the Union address. The president travels to the House of Representatives, stands up before the House, and gives the State of the Union address. Next, the president is able to recommend to Congress measures that would be necessary or expedient for Congress in order for the nation to carry out its functions. The president also has the power to receive ambassadors and other public ministers. The president must also take care that the laws be faithfully executed. This is also really important from the prosecutorial standpoint. We will talk in a couple episodes about how much control the president has over the law enforcement function. And one of the leading clauses in that particular debate is this particular clause. It's called the take care clause. Right? What does it mean to take care that the laws are faithfully executed? Finally, the president has the ability to commission all the officers of the United States and to give them their particular positions. The last piece for the president is removal. Right? The president may be removed by impeachment, and that is only for treason, bribery, or other high crimes or misdemeanors. So the key thing is, if the president is accused of some sort of criminal conduct, the president doesn't go through an ordinary criminal trial. Instead, the House of Representatives must impeach the president, then the Senate holds a trial to determine if the president is guilty or not, and then, once they determine the president is guilty, they vote whether or not the president should be removed from office. So that's how the removal process works. And so that brings us to our third branch, the judiciary. That is Article 3 of the Constitution. Basically, Article 3, Section 1 vests the judicial power of the United States in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. So Congress is going to have that power to create additional courts, or they don't have to create any courts. If Congress wanted to, they could wipe out the entire federal court system and simply just leave the United States Supreme Court. Now, from the very beginning in 1789, when the Constitution first took effect, there have been inferior federal courts. And so we're not going to wipe out all our federal courts, but Congress does have that power. Now, the question is, how far does this federal judicial power extend? What types of cases can federal courts hear? And so that is what the Constitution sets out, and it sets out two different types of jurisdiction. It sets out original jurisdiction and appellate jurisdiction. Original jurisdiction simply means it's where cases begin. They have the authority to begin the case. If I have a complaint against you, I'm going to file it in a court of original jurisdiction. The second type of jurisdiction is appellate jurisdiction. They have cases, they review what the courts of original jurisdiction do. So if I have a complaint against you, I bring it in a court of original jurisdiction. That court decides against me. I'm going to take it to a court with appellate jurisdiction who is going to review that and, from my perspective, hopefully reverse what the court of original jurisdiction did. The Constitution, when it establishes the Supreme Court, gives it both original and appellate jurisdiction. Which it has is depending on the type of case. The Supreme Court has original jurisdiction in certain instances. In any case that is affecting an ambassador, a public minister, or a counsel. So anyone who basically is working for a foreign government who is in the United States, the U.S. Supreme Court would have original jurisdiction over that. It's also going to have original jurisdiction in controversies between two or more states. So let's say that the state of New York is dumping a whole lot of trash into its waters, and those waters are then connecting to New Jersey and polluting New Jersey. New Jersey wants New York to pay for this. So New Jersey is going to sue New York. That would be a case where the U.S. Supreme Court would have original jurisdiction. It's also going to handle controversies between a state and citizens of another state. So let's assume that New York is dumping a whole lot of trash into the water, and now it is washing up on a resort that I have on this particular beach in New Jersey. And so I'm a citizen of New Jersey. I'm going to sue the state of New York for dumping all of this trash into the ocean, and it is damaging my property in New Jersey. So that would also be a case where the U.S. Supreme Court would have original jurisdiction. It's also going to get involved have original jurisdiction when there's a controversy between a state and a foreign nation. So let's again put New York. They are dumping a whole lot of trash into Lake Ontario. That is then washing up on the shores of Ontario, Canada. And so Canada is going to sue New York to collect money for the damages that trash has caused. That would also be an original jurisdiction case in the U.S. Supreme Court. In all other instances, the United States Supreme Court has appellate jurisdiction. What are some of those cases? Well, any case in law and equity that arises under the Constitution, the laws of the United States, or any treaties the United States has made. This is a very broad collection of things, especially today. The United States Code is made up of 50 different titles. There's literally tens of thousands of criminal statutes that are located in the United States Code. And as a result, the Supreme Court would have appellate jurisdiction over all of those cases. They also have cases over what we call admiralty and maritime jurisdiction. Involve, who can use those particular waterways. What if one boat runs into another boat, right? All those different things will get to the U.S. Supreme Court on appellate jurisdiction. There are controversies where the United States is a party. So anytime anyone sues the United States for anything, that case could go to the U.S. Supreme Court on appellate jurisdiction. There is also the idea of controversies between citizens of different states. So if I'm living in North Carolina and I want to sue somebody in Virginia, that is something that will go to the Supreme Court on its appellate jurisdiction. Now, Congress also has the ability to limit this authority. So Congress can remove jurisdiction. They cannot add jurisdiction to it. So Congress doesn't have to give the Supreme Court authority to hear all these cases, but the Constitution at least allows it. A couple other important provisions that are in the Article 3 judicial branch section of the Constitution. All trials must be done by jury. That's in the actual part of the Constitution. It's also reiterated in the Bill of Rights. In addition, the trials must be held in the state or district where the offense occurred. So again, if I commit a federal crime here in North Carolina, I have to be tried in one of the federal judicial districts of North Carolina, that being the one where I committed the offense. If the offense wasn't committed in a state at all, then Congress has the ability to designate where this takes place. We may look in our case studies series at people who have never ever been to the United States before, yet they're being prosecuted for violating United States law. Where are they going to get prosecuted? We can't prosecute them in a foreign country. So Congress has said, under these circumstances, these types of cases will be tried here or there, depending on what Congress has decided. So that concludes our look at the Constitution as a whole and what the different powers are the different branches have. And again, we're going to see just about every state has identical provisions where they are going to break out their powers into three distinct branches, and those different branches are all going to have similar types of powers. So the legislative branch can make the laws, the executive branch is responsible for executing those laws, and the judicial branch is responsible for adjudicating disputes that arise under those particular laws. Now, what the founders did not fully anticipate when they were creating the Constitution was that there would be a professional group of people who are required to manage the day-to-day operations of the government. Back when the Constitution and the United States government first began, there were certainly people who were employed by the government. As the nation grew, as the demands on the federal government grew, so too did the number of people who were working for the government. And so what essentially was created was in what we call the administrative state. It's people who are responsible for administering the different functions of government on a day-to-day basis. Prosecutors often fall into this idea of administrative state. We will see that we have some prosecutors who are politically appointed. We have others who make this their career. And so the question becomes, how much authority can the federal government or even the state governments exercise over these career officials? So when the Constitution envisioned these particular departments, they anticipated people would be working in them, that they would be small. The original ones were few. There was the Treasury, there was the War Department, there was the Secretary of State, there was the Postmaster General, and then the Attorney General was created separately. And so you see, there wasn't much for them to do necessarily. They didn't have big staffs like they do today. Again, as these departments and agencies grew, they began to make their own law. They began creating their own regulations for how things should work. They are regulations that we encounter every single day. So when we are driving our cars, those cars are regulated by the federal government. The Environmental Protection Agency says certain standards must be met. When we are going to the grocery store to get food, the food is subject to inspection and approval by the United States Department of Agriculture. They have certain rules and standards that must be met. So the question becomes, how do they get this power? How does somebody in the Department of Agriculture get to say how many bugs are allowed in a particular jar of jam, or what we call jam versus what we call jelly? That is all power that's delegated to the agency by the legislature. So the legislature has said, Department of Agriculture, it is your job to set these things off, go do it. And so they go and create these regulations. In addition to creating these regulations, they have to go enforce these regulations. So all these different agencies then have enforcement power. They can sue people, they can get injunctions against people, they can prosecute people who are violating these particular regulations. Because you have these full-time professional people who are working on these issues on a day-to-day basis, they become experts in these issues. They may have specific scientific knowledge and background that allows them to function in this area. They may have specialized training in this area. They may do research in this area. Right? So they become subject matter experts and are there also then to provide advice to the executive when the executive is setting forth policy. The problem from the president's perspective is that the president comes in with these experts already there. The president leaves, those same experts are already still there. The experts are not necessarily responsive to the president. They may disagree with the president's policy choice. They may act to undermine the president's policy choice. And so this raises our particular question of how much control does the president actually have over these essentially subject matter experts that work for the government? Are they subject to being fired simply because they have the temerity to disagree with the president? Should the president be allowed to select experts that the president wants to hear from? Should they simply be people who are saying, yes, Mr. President, do whatever it is you want to do. This is a good idea. We will go implement it for you. Or should they provide a more independent voice and say, Mr. President, if you do X, these are going to be the negative consequences that flow from it. This continues to be an ongoing tension in our system, and we're trying to figure it out legally of what the Constitution requires and how much control the executive has over what is essentially termed the administrative state. So that wraps up our look at the 3 key aspects of government that we need to understand when we are looking at the government structure in which a prosecutor operates. We started off with federalism. We have to understand that we have dual sovereignty in the United States. We divide it between the federal government and the 50 states of the United States. Then we looked at the separation of powers. What does the legislative branch, executive branch, and judicial branch, what are their respective constitutional powers? And then finally, because of the size of the government and all the different things that it's called upon to do, we have this group of people who serve in the administrative state, who oversee government power. And the question becomes, how much control does the executive branch have over those people? Now, in our next episode, we are going to look at the criminal courts, and we're going to see how the criminal courts operate. Once we have that, and we have the government structure, then we can look at what prosecutors themselves do, which is episode 3. Thank you for watching. Please subscribe to this channel. You can also find us through the Politics of Prosecution Podcast. You can find us on Instagram at POLI_N_PROS and on Twitter at POLI_PROS. Thank you, and we will see you next time.